Hi, good morning. This is attorney Amy Refeca, and I am here live, Facebook Live, for Wills on Wednesday. Really excited to be here, jumping on a little late this morning because of an early morning appointment with a client. However, nonetheless, we're here today to talk about financial powers of attorney, and we're specifically here to talk about this really important document in any person's estate plan, and how often, what is this document? How often should you have it reviewed? And more importantly, there is a new law here in the state of Georgia that went into effect on July 1st, 2017. And we're coming up on the year anniversary of that law here in July. And I just wanted to ensure that everyone here in the state of Georgia that potentially had a power of attorney before July 1st, 2017 has had that document reviewed by their attorney, just to make sure that the document works for them in the event that they need it. So what is a financial power of attorney? Well, in short, a financial power of attorney is a document that it's a legal document, legally binding, has legal authority, and it is one person, the person who signs the document, who creates the document, giving authority to another person or another entity, another company or corporation, to make financial decisions for them in a few different scenarios. Either they can make it completely on their own, those financial decisions for the person who creates the document. They can support and advocate for the creator's financial decision, or they can, again, if in the event that someone is no longer able to make financial decisions, they can make decisions for that person. So let's play that out. A financial power of attorney, really, they can be used in various ways, but let's play out how in reality they're used. So I work with a lot of women who are older, say past retirement. Either they were divorced or they have lost their spouses previously, and their adult children is more involved in their finances in their life now. I work with a great number of women who are in this space, say in their 60s, 70s, 80s, and even 90s, and perhaps their son or daughter, more usually it is the daughter, is helping mom just get through the mail every week, take care of their bills. Maybe there's an insurance dispute, or maybe something came in the mail that just didn't look right, and your child is helping you walk through that, or that child is helping walk through that financial situation. Well, in that particular circumstance, a financial power of attorney is incredibly helpful because it allows that child to step in, talk to the financial institution, and work through, why is mom being billed? Why is mom being charged for something she didn't use? Why is mom, now financially responsible for something when the insurance should have paid for it? Or why is mom's cell phone bill suddenly doubled? What happened? What changed? So all of these things, a financial power of attorney can help someone work through. There are other ways that a financial power of attorney can work. And that is when someone is incapacitated, not just doesn't want to deal with it in the situation before, where, mom really just doesn't want to deal with the insurance company, so asks their daughter to step in and make a phone call to the insurance company or to AT&T or Verizon or whomever and make that phone call to figure out that bill. That's one situation. Mom's aware, mom knows, mom wants daughter to step in and deal with that financial situation. The other situation where a financial power of attorney becomes helpful is if you cannot make these financial decisions for you. And I am confronted every day with family members and phone calls and conversations with family members where a family member has to step in because mom or dad can no longer handle their own finances. And in that situation, Or even if they're really young, something happens and they cannot either temporarily or permanently handle their own finances. If you do not have a plan in place to decide who is going to step in and help you with your finances, then that could be decided for you by either your family members, and it could not be the person that you want to have handling your finances, or a court would have to step in and decide. And anytime you get a court involved, then we are looking at a situation where, someone else is going to make that decision for you. And we don't want that. We want absolutely that decision to be your decision. So a financial power of attorney, basically, if you become incapacitated, makes the decision of who you want to step in and make decisions for you for your finances, instead of a court deciding who steps in and makes your financial decisions. Or even worse, having a court-appointed non-family member step in and make decisions for you because perhaps your family is having a disagreement over who that should be in your family. Someone has to make financial decisions for you. It's either going to be of your choice through a financial power of attorney, or it's going to be a court deciding who the best family member is or who the non-family member is who should be making financial decisions. So that's what a financial power of attorney does for you. It can make small financial decisions on, hey, let's go to the grocery store and write this check. It can make huge, super large financial decisions for you, like selling real estate. So that's what a financial power of attorney is. And let's talk really quickly about the new law in Georgia. Now, I still call it a new law because it's less than a year old, but on July 1st, 2017, a new law actually went into effect. It was signed early in 2017, but a new law went into effect about financial powers of attorney. The form changed somewhat. The way it looks changed somewhat. The requirements in what the form has changed somewhat. And it became a stronger, more powerful document to help people who need help with financial decisions. And, just to be clear, it does not invalidate financial powers of attorney that were in effect before July 1st, 2017. But it does provide significant safeguards for individuals in using their power of attorney when they need it. And so if your power of attorney does not comply with the law, then you may not be able to use it when you need it because of the new law. A bank can reject it, in short. And so what we are recommending is if you have a power of attorney that was created and signed in the state of Georgia before July 1st, 2017, reach out to your attorney, reach out to us here at Atlanta Wills and Trust Law Group, and we could do a quick review and we can tell you yes or no, your power of attorney is at risk of not being effective and working for you when you need it. And that's really the message here. I guess you could call it a PSA, a public service announcement. If you have a power of attorney, if your parent has a power of attorney and you are using it, or you think you may be using it soon, and your parent still is able to sign a new financial power of attorney, then get that reviewed. Reach out to an attorney and ask to see them, ask them to review it, and just provide you some feedback about whether you are at risk or that power of attorney is at risk of being rejected here in Georgia as a result of the new law. Banks are aware of the new law. Financial institutions of all shapes and sizes are aware of the new law. You should be too. This is Attorney Amy Refeca here at Atlanta Wills and Trust Law Group. Thank you for joining us this morning. And if you have questions about this financial power of attorney law, reach out to us. We have a free resource. We have a few free articles explaining the new law and how it works and how it could work for you and help you and your loved ones. Thank you for joining us.